Okay, so now listen attentively. The product of the day is employees compensation insurance. Before we start the product, let us understand the background of this category. See, in the before independence days, when there was no law, no act, factories and industries were still there and they were hiring the people. And those people were suffering accidents and losing their body parts, suffering disabilities, death or injuries. There was no provision to pay any sort of compensation. My voice is clear?
Yes, sir.
Okay. So there was no provision of paying the compensation. It was the story of the before independence. Then some large Jagendra Union, those communists came into the picture. There is some voices in favor of labours. And then the British government formulated an act. That act was called Workmen's Compensation Act 1923. 1923 means exactly 100 years ago, because this is 2023 over now. So that time this act was formulated, and that act provided for the compensation for the workers, and the formula was set in the act to calculate the compensation for in case of death, disability or injuries or for everything. And the compensation was paid according to the formula provided in the act. So that act is still continuing with some sort of modifications or amendments. So let us see what this policy is. This is commonly known as the Employees Compensation Act, and in compliance of that there is a policy called Employees Compensation Insurance. This is basically a social security legislation. Why? Because the aim of this act is to provide the financial protection to the workmen or their families, or you can say their dependents, in case of accidental injury. So by means of payment of financial compensation, they are financially supported. That is the reason this act is called as social security legislation. It means this is providing social security to the workers, to the laborers, to the employees and their dependents. Now, over the period of time, certain amendments have taken place in this act, and major of them were two only. First one is to change the name of this act. Initially it was Workmen's Compensation Act 1923. Subsequently, only in the year 2000, it has been amended as Employees Compensation Act 1923. So similarly the policy was there, Workmen's Compensation Insurance. Now that policy is also named as the Employees Compensation Insurance. So this is one major amendment. Second major amendment is, at that time when this act was formulated, the wages were paid in hundreds of rupees, 100 years ago. Even 100 rupees were much more. So after a long time, the amendment was made in the act and the wages was increased to the limit of rupees 4,000 per month. Again, over the period of time, the wages was increased to 8,000 rupees per month. And now recently, in 2000, the wage level has been increased to the limit of rupees 15,000 per month. So currently the wages applicable is 15,000 rupees per month. This is the limit. Now the question is, these two major amendments have been made in the Act. And these are both now continuing. So as per section 17 of this Act, the employee has got a right to recover the compensation from the contractor instead of the principal. Normally this policy is taken by the contractors because they are hiring the laborers who are engaged in the construction of buildings, production of plants, and any kind of works. So the principals or the employers or the contractors are the people who are taking this policy to protect the financial rights of the employees. So this is a legal right of the employees or the labor or the worker to claim the compensation in case anything happens during the working hours. But if at all anybody is asking to you the policy called employee compensation insurance or the workman compensation insurance, you don't need to get confused over it. Because the meaning of both is same. Both are in compliance to the Employees Compensation Act 1923. Only the name has been changed. Rest of everything is the same. And the basic aim of this Act, or the object of this Act, or the social security which this Act is providing, is by way of providing relief, that is financial relief, to the workman or to their dependent if workman is dead or disabled or injured or suffering any occupational disease during the course of employment due to accident arising out of and in the course of employment. This is a legal terminology of the Act. So this is the only basic scope of this Act. This is the only aim and object of this Act. Now, this situation may arise because of many reasons. Say for example, an employer is negligent, not providing the required amenities, or the employee is negligent, not following the rules and regulations, or the fellow colleagues or worker is negligent. Because of his negligence, anybody can suffer the injury or disability or death even. Or the breach of statutory regulations could be there. Certain stipulations are there in the Factory Act to provide the safe place of working. If there is any violation, that may result into the harm, bodily harm to the workers. And failure to provide safe place of work by the employer. All these are the reasons which are contributing to the death, disability, injury of workers, employees or laborers. Now, accident doesn't mean a pre-designed, a pre-planned incident. No. Accident is always unexpected, undesigned, unplanned, untoward. And how much it will impact, how much it will injure, how much loss it will cause, nobody knows. Beforehand, you cannot even imagine what will happen. That is accident. In the course of employment means it indicates the time when the injury is caused. And that time should be the working hours. Because out of working hours, if worker is suffering anything, that is not the employer's fault. If the person is on leave, he is doing some work at home and he suffered the disability, employer is not responsible for that fault. So out of employment refers and establishes the causal connection between the injury and the employment. Because that is not the coverage of the policy. That is not required to be compensated by the employer. In the course of employment is the important part. So what actually this act is covering? The liability is very limited on the grounds because the employer is responsible to pay compensation to the employee or to his dependent who suffered an accident arising out of and in the course of employment, resulting into 5 categories only: death, permanent total disablement, permanent partial disablement, temporary disablement, maybe total or partial, and if the worker has contracted an occupational disease. This occupational disease is one reason which some insurers are covering in the basic coverage of the policy, that is inbuilt coverage. Some are charging additional premium to cover it. It depends. But that coverage has to be there in the policy. So basically, these things are covered under the policy and nothing, not even medical expenses. Because if the worker is suffering any injury and the amount of say 2 lakh or 3 lakh rupees is required to the treatment of injury, even those medical expenses are not paid. So here he has to see liability is limited on these grounds only. But when you are selling this policy to any of your customers or contractors or employers or principals, you will face 2 important questions. The customer or the contractor may ask you, how will you decide the premium of the policy? And secondly, if by any of the workers has suffered any injury, death or disability during the working hours, how will you pay the compensation? What amount will be paid? Both are the important questions because this policy is based on these 2 answers. The method of calculating the premium of this policy is absolutely different to the other policies. Here the method is, if you want to calculate the premium of this policy, you need 4 basic details from the proposer. Proposer could be contractor, employer, principal, and the detail of all the 4 things is required. Even if the detail of 1 is missing, you cannot calculate the premium of the policy. What these 4 things are? First, number of employees or workers or laborers. Second, wages or salary of these employees per month. Third, period of insurance in months of this policy. And fourth, nature of work. All these 4 informations are required to calculate the premium of the policy. I repeat, number of employees or the workers or laborers, wages or salary of these employees per month, period of insurance in months, because the period could be 1 year or less than 1 year also. If the project is of 3 months, 6 months, 8 months, so obviously the contractor will take the policy for limited period only, not for 1 year. So period in months and nature of works. Now the important thing is, suppose the proposer is providing you the detail of all the 4 things. How will you calculate the premium? So the method of calculating the premium is, you have to multiply first, second and third. First, second and third means number of workers, wages of the workers and period of insurance. These things have to be multiplied. Now whatever sum is coming, on that you will apply the premium rate which is given in the employees compensation tariff according to the nature of work. Now, nature of work differs everywhere. Project could be of anything. Even the factory owner, industry owner, office owner, shopkeeper, house owner, anybody can take this policy. Wherever the worker, laborer or employees are working, this policy can be given because ultimately the liability is statutory liability and the employer has to pay the compensation if any accident is causing an injury, death, disability or injury to any of the workers. The huge amount of liability has to be paid. So to calculate the premium, nature of work is also important. Now, when you have multiplied number of employees into salary of these employees into period of insurance in months, then only you are applying the rate which is depending on the nature of work and it is given in the tariff. So on that tariff, because the tariffs have been dismantled from the point of view of the pricing. So whatever rate is given, the underwriter or the insurer is authorized to give the D-tariff discount on that premium rate. That is secondary. But the nature of work will decide the premium rate. So how this will decide? About the rate, two things are important. One, all the WC rates are in per million, means per thousand. Secondly, if the wages is exceeding the level of 15,000 rupees, in that case, over and above whatever amount is there, on that also some part of rate is applied. So the contractor need not to hire the actual wages. He has to disclose because nowadays, even if you are hiring a mason, a mistri for your household work, his normal rate is 800 rupees per day or 1000 rupees per day. Even if he is charging the 800 rupees per day and he is working for continuously for a month, so he is taking 24,000 rupees per month. He is a laborer, he is a worker only. So if you want to cover his risk, up to 15,000 the premium rate would be different, and over and above 15,000, some part of rate will be applicable. So the contractor should not hide this fact. Now how the premium will be calculated? Say for example, I am a contractor, I have a farmhouse. Now in my farmhouse, some say 30 workers are there and they are all engaged in the farming. It's a big farmhouse. But I know if anything happens to my workers during the course of employment or during the workers, if anybody dies, if anybody is disabled, this is my responsibility to pay them the compensation, and why should I pay this compensation which is in lakhs and millions of rupees from my own pocket when the risk can be transferred to the insurance company easily by taking the policy. So I will definitely prefer to take the employees compensation insurance policy, and by paying some amount of premium, the total risk is transferred on the insurer. If anything happens to any of the workers during the course of employment, insurance company will pay the compensation. This is so simple because this is the best method of risk management. So now, when I am taking a policy for my workers of the farmhouse, the basic detail required I have provided. I have 30 workers. I am paying to them 10,000 rupees per month. I need a policy for 1 year, means 12 months, and all workers are engaged in the farming. So when you are calculating the premium, you have multiplied the detail of first, second and third. And now whatever sum is there, on that you want to apply the premium rate. So for premium rate, you have to refer the tariff. In tariff, you will find for agriculture farms, The rate is 5.85 per milli. So whatever sum is there, on that you will apply the rate of 5.85 and your premium is there. It is so simple. This is simple only when the information of all the four things are there with you. When you have received the information from the proposer or the contractor, you can simply calculate the premium by multiplying all the first three and by applying the premium rate according to the nature of work. Now the question is, the job or the nature of work could differ. Contractor to contractor, employer to employer, principal to principal. So say, take another example. Suppose I have a factory of aerated waters. I have around 150 laborers. Some 100 workers are unskilled. For them I am paying 10,000 rupees per worker. 50 workers are skilled. Those are working on the plants, manufacturing plants. For them I am paying 15,000 rupees per worker. Now I know anything can happen during the entire year. And maybe multiple incidents can take place. So why should I bear this liability? I would definitely like to invite you to cover this risk. So when you are asking me the four questions, I am providing you the detailed number of workers, 150, wages of these workers, 100, for 100 I am paying 10,000, for 50 I am paying 15,000. Policy is required for 12 months, that is 1 year. And the nature of work is they are working on the plant of aerated water manufacturing. Now you have referred to your tariff and you find the rate for aerated water manufacturers is 15.10. So you have multiplied the sum of these three things and you have applied the rate. Simple method of calculating the premium, no complication at all. There could be some risky proposal where the nature of job is very risky. Even one instance can result into the death of many workers or employees or laborers. In such a situation, even the risk is coverable. But obviously, where there is a high risk, the premium will be high. This is the basic point of the insurance. Higher is the risk, higher is the rate of premium. Lower is the risk, lower is the rate of premium. So say suppose I am running an institution where I am hiring the pilots. Now for first 6 months I have to train them and thereafter I am assigning the job of pilot to them. So this period of first 6 months is very risky because in training period anything can happen. Once they are trained, then they are the full-fledged pilots. So for this specific purpose I want to take the policy because this is the very risky period, anything can happen. So I invited you to cover the risk. When you ask for the detail, I provided you, I have 50 employees. I am paying to them 15,000 per month. Period of insurance is required only 6 months. And then nature of work is to fly aeroplane, helicopter or any air device. Because ultimately they are going to be the pilot. So when you refer to your tariff, you find the premium rate for pilots and employees who may at any time fly any air device. The premium rate is 121.60, 121.60. Here the important question is you may get surprised because the rate difference is very high. For agriculture farm it is 5.85, for aerated water manufacturer it is 15.10, for pilots it is 121.60. So the reason is simple. Higher is the risk, higher is the rate of premium, lower is the risk, lower is the rate of premium. Simple method. So when you are providing the policy, you have multiplied the premium. 50 into 15,000 per person into 6 months and then the rate is 121.60. So your simple premium is calculated. But This is the method of calculating the basic premium. Now comes the extensions or add-on covers. I told you if the policy even not providing any coverage for the medical expenses, which is a continuous requirement since day one. Because any worker may suffer any injury due to plants or due to accidents or for any mistake during the course of employment. So this is invariably required. So whenever you are selling this policy to any contractor or employer or any principal, you must suggest from yourself that medical expenses cover is required. You can pay a little extra premium and take this add-on cover. Here the option is given for the proposer to select any limit because the premium is chargeable according to the limit selected by the proposer. And limit starts from the 5,000 to 5 lakh and even to the actual expenses paid. Say suppose the employer feel 1 lakh rupees is enough per worker per year. So he has to pay only 75% premium and that would be minimum 2,200 rupees per person. But if he feel that I don't want to pay any medical expenses from my pocket, whatever amount has to be incurred on the treatment of the injured workers, that has to be paid by the insurance company. That is also possible. By taking this add-on cover, whatever amount is incurred on the actual treatment, that actual expenses will be paid by the insurance company because the insured is paying 150% of the premium, that is minimum 700 rupees per person. So this medical expenses add-on cover is most important, where the limit has to be selected by the proposer himself. And you must suggest it because this is not the basic risk or this is not the inbuilt risk which is part of the policy. In the inbuilt risk we have seen only few risks are there, that is death, permanent total disablement, permanent partial disablement, temporary disablement, whether total or partial or the occupational disease. So when you are providing this add-on cover, the limit has been selected by the proposer. Second add-on cover is
Is it not heavy charging or partial?
Yeah, come back.
सर ये तो आपने लास्ट स्लाइड के अंदर मेंशन किया था मेडिकल चार्जेज. अगर मान लीजिए किसी ने 3 महीने का डब्ल्यूसी लिया है, 6 महीने के लिए डब्ल्यूसी पॉलिसी लिया है, कोई कंपनसेशन में मेडिकल ले रहा है, तो ये जो है ये कैलकुलेट कैसे होगा?
कैलकुलेशन बड़ा सिंपल है.
या अदरवाइज
Just listen, calculation is more simple because see, this is chargeable per person also. This, see, 60% of the PM rate or 75% of the PM rate or minimum 200 per person. So whatever comes, if the minimum is 200 rupees per person for 1 lakh, you will charge 200 rupees per person. And one most favorable point for you is sometimes the premium of medical expenses add-on cover could be higher than the actual premium of the policy because it all depends upon the number of workers or the laborers or the employees. And for you, one more extra advantage is because the WC calculator is provided to you. You only have to fill up the number and the limit. That will automatically calculate it. Premium chargeability, suppose the proposer is selecting only the 5,000 rupees per person per worker limit. He has to pay 30% of the premium rate or 80 rupees per person, whatever is minimum. So this premium rate is given here. For that you don't need to worry. You only have to look at that you are suggesting this add-on to the proposer and providing this add-on because this may give you good amount of premium. Secondly, this will provide a wider coverage to the proposer because he must take this cover, otherwise he has to pay a huge amount from his own pocket in case of injuries of the workers during the entire policy period. Second one is occupational disease. Occupational disease means the disease or the sickness contracted due to the nature of work. The premium rate is only 50% of the book rate. But the occupational disease may cause the worker the skin infection, lung infection, eyesight infection, hearing impairment, or even TB, lung infection. Because it all depends upon the nature of work. Say suppose, for example, a welder is there. Now welding is one thing which need a special kind of glasses. Now a worker is engaged in welding only since last 3 or 4 years, 5 years, 6 years. Over a period of time, his eyesight may start losing. He may lose the complete eyesight also. So how this occupational disease has come? Because of his occupation, because of his nature of work. Had he been working on any other thing, he may not have suffered this kind of disease. And you must have seen, say, in textile mills, where the workers are engaged in spinning the cotton. So all the time they are spinning. And in the cotton they will find dust particles. Those dirty dust particles they are inhaling in with the breath. So that is amassed in the lungs. That may cause lung infection also. These are the diseases which are caused by the nature of work. So they are called occupational diseases. But there is a coverage for that. An additional premium, that is 50% of the book rate is applied, but this risk can be covered. Third add-on cover is insured liability for contractors or subcontractors employees. The contractor's liability is covered in the policy, but maybe the contractor may have 2 projects, 3 projects, where he has a subcontractor and the worker who is also working. So he would definitely prefer to take the coverage for those projects also in the same policy. And that can be provided. The only thing is he has to disclose the actual number of workers and the actual amount of the wages paid. Because both are the part of the premium calculation. If he is hiding any of these information, the correct premium cannot be calculated. And when you are selling this policy, what is preferable for you is to ask for the muster roll and the wage register. That will clearly confirm that how many workers are there and what is actually paying. Because the confusion is only on that point that they are under the impression that the workers who are getting the salary up to 15,000 will be covered only. This is not the case. Worker who is getting even the 30,000 rupees per month can also be covered under this policy. Only thing is the premium has to be paid over and above the amount of 15,000, and that is again less than the premium rate. So they should not hide this fact. This add-on cover can also be given. Now the question is, when you have understood how the premium will be calculated on the policy and what 4 information are required to calculate the premium, thereafter, after calculating the basic rate, you have added 3 add-on covers if the insured has selected. If you have selected 1, for 1 you can add the premium, for 2 you can add the premium, for 3 you can add the premium. This is as per the choice of the proposer, because no add-on cover is binding upon any buyer. These are always optionals. So when you have added this premium to the basic premium, your premium for the policy is there. So the first question is answered, how the premium of this policy will be calculated. Simple. Coming to the second part. Suppose any worker has suffered any kind of injury or disability or death, how he or his dependents will be paid the compensation. This is again very important. But for calculation of these things, amount of compensation, you need only 3 things. What 3 things are there? First thing, nature of injury. What actually the worker has suffered. Is it death, disability, injury, occupational disease, what it is. Second thing is monthly wages. How much he was earning at the time of incident. Third thing is the relevant factor. Now this relevant factor is specified in Schedule 4 of the Act or the tariff. This will not be provided by the insured. This you have to take it from the tariff or from the Act. This is already given there. Relevant factor is based on the age and income of the worker. The most important aspect of this Act is there is no distinction between an adult and a minor worker with respect to the amount of compensation. When this Act was formulated, at that time there was no strictness. The factory owners or the shopkeepers were maybe hiring the workers who were less than 18 years of age, 14 years boy, 15 years boy, 16 years boy. So if the worker is less than 18 years or over 60 years and he has suffered any injury or death or disability during the working hours, compensation has to be paid as per the provisions of the Act. There is no distinction between an adult or a minor. But this relevant factor is important because the relevant factor is there in the tariff. What is this? Let us have a look at it first. Then only you will be comfortable to calculate the compensation. There is a chart given in the tariff. This is the relevant factor applicable only for the case of death. Say suppose the worker is getting 15,000 rupees per month. His age may be 40 years. So for 40 years, this is 184.17 is the relevant factor, and the amount of compensation payable in case of death is 13,81,275. Everything is calculated. You don't need to do anything. Here in this table you will find that this table starts from the 16 years and the standard is 65 years. But the worker may be less than 16 years, 14 or 15. In that case again this will be applied. 16 years ban will apply. Worker may be of the 70 years or 72 years. In that case again the 65 years ban will apply. And the basic funda of this table is lower is the rate age, lower is the age, higher is the compensation. Higher is the age, lower is the compensation. Suppose a person of 20 years died, the compensation payable is 16,80,000. But if a person of 70 years died or 65 years died, the compensation payable is only 7,45,275. Because for the persons of lower age, there are responsibilities. There may be dependents. They are the only bread and butter earners. But under any circumstances, the compensation for death of a worker cannot exceed 70,14,050. This is the maximum. Lowest limit is different, but maximum limit is defined here. 17,14,050 in case of death. So another relevant factor table is for permanent total disability. Here the compensation has to be higher than the death. The reason is very simple. Because in case of death, the worker is no more. One-time compensation is paid. But in case of permanent total disability, the worker may have lost his body parts, totally disabled, he may not be in a position to earn, he may not be in a position to work, and still he has to survive because he is alive. He is only permanently totally disabled. His family is also there. The compensation has to be higher. So here the relevant factor would be the same, but the percentage would be higher. Age limit is according to age, the relevant factor has to be taken. But here in permanent total disability case, the maximum compensation limit is 20,56,860. 20 lakh. This is greater than the death case. So these two tables are already there. Here from you can easily pick up the relevant factor. You don't need to because the compensation will be settled by the claims department and the amount would be calculated either by the claim department or the employer himself or the Commissioner of Workmen Compensation. There will not be any differentiation because the formula is the same. So, the formula is the compensation for death 50% of the monthly wages multiplied with the relevant factor. That is all. Here the minimum limit is 1,20,000. That means under no circumstances the compensation in case of death could be less than 1,20,000. But at the same time, it cannot be higher than 17,14,050. So this is the highest limit, and that 1,20,000 is the lowest limit in case of death of a worker. Simple. But compensation for permanent total disablement. Here the formula is 60% of the monthly wages. That means the percentage has been increased as compared to the death. 60% of the monthly wages multiplied with the relevant factor, and here the minimum compensation payable is 1,40,000. Maximum you have already seen, this is 20,56,860. So both the limits are there. Only thing is, when the permanent total disablement is there, that means the worker or the employee or the laborer is completely disabled for the rest of his life due to illness or injury because he has suffered. For example, loss of both the hands are there, loss of both the legs are there, loss of both the eyes are there, or he may suffer complete paralysis, or he may have suffered loss of one hand and one leg, he may have suffered loss of one eye or one hand. So this is permanent total disability. Doctor will certify it. Sometimes there could be permanent disability more than 100%. Say suppose in any accident the worker has suffered, he has lost one leg, one hand, one eye. Doctor has to certify 150% permanent total disability is there, but under no circumstances the policy can pay the compensation for more than 100%. So there are certain circumstances where the permanent total disability has to be certified by the doctor. Now how the premium will be, the amount of compensation will be calculated. This is very simple. Say a worker in a factory of 46 years died due to accident during the working hours. Simple example, I repeat. A worker of 46 years died due to accident during the working hours in a factory. He was getting the salary of 15,000 rupees per month. Now to calculate the compensation amount, you have to apply the 50% formula of the death. 50% wages is 7,500. He was getting 15,000. So 7,500 will be multiplied with the relevant factor. Now you can see the age is 46. In case of age of 46, this is the relevant factor. In case of death, 166.29. So when 166.29 relevant factor is taken, this is multiplied with the 7,500. So whatever sum comes, that has to be paid. What sum comes? The sum is 12,47,175. This will be paid because the minimum limit is 1,20,000 and the highest one is yet to be paid. So here 12,47,175 as it is will be paid without any sort of deduction. There is no compulsory excess, there is no salvage, there is no depreciation. This amount has to be paid as it is because the provision of the Act is there. Either the Commissioner of Workmen Compensation is calculating it, or the employer is calculating it, or the contractor is calculating it, or the insurance company is calculating it. It makes no difference because the formula is decided. Had it been the case of permanent total disability, in case of 50%, the formula would be 60%. That is the only difference. So this is the way of calculating the compensation. Take one more example. Suppose in a small shop, the shopkeeper has a servant. He is paying him only 3,000 rupees per month. He is 30 years of age. So when he was cleaning the shop, some fan or some cooler fallen on his head and he died at the spot. So the ultimate liability is of the shopkeeper because he died during the course of employment. His family even filing a simple application without an advocate to the Commissioner of Workmen Compensation, that is called Labour Court. He may issue the summons, he may pass the orders also. So what would be the compensation payable here? The shopkeeper has to pay here 50% of the wages. Wages is only 3,000, 50% is only 1,500. Multiplied with the relevant factor at the age of 30, that is only 207.98. So the amount payable is only 3,11,970. Since it is more than 1,20,000, this amount will be paid. But this will be paid to his dependents. Here, in case of death, this is most important because the nomination must be there in the policy itself. If the nomination is not there, take it granted the insurance company is not going to pay the compensation. Because the insurance company doesn't know to whom the compensation has to be paid. So the nominee's name must be there. So this is the simple way of calculating the compensation. And here again, in the same example, suppose the person has not died, he has suffered the permanent total disability. What difference would we have? We would have been there. 50 will be replaced by 60. 60 into 3000 into 207.98 upon 100. Whatever amount comes, that is payable. Simple. This is in case of death. Now, the limit in case of death is maximum limit you have seen. Formula is 15%, minimum is 1,20,000. In case of permanent total disablement, formula is 60%, minimum is 1,40,000, maximum is 20,56,000. Where permanent partial disablement is there, that partial disability has to be checked because this under these circumstances there is a total disability. Permanent total disability. Loss of both the limbs, loss of both eyes, loss of both hands, loss of both legs, loss of one hand, one leg, loss of one eye, one hand. These are the combinations where the permanent total disability has to be certified by a medical doctor. But when the partial disablement is there, that means certain percentage has been disabled. Say suppose one eye has lost, unable to speak. This is permanent partial disability, not total. In case of partial disability, whatever percentage is certified by the medical doctor, that percentage has to be paid. It could be 90%, it could be 20%, it could be 9%, it could be 2% only. It all depends upon the medical doctor because he is the person authorized to certify the disability. Whatever compensation is payable, out of that, only that percentage will be paid, which is certified by the medical doctor that a permanent partial disability is 14% or 40% or 94%. Ultimately, the compensation had to be paid through the Commissioner of Workmen and Compensation only. Because he is the ultimate authority which will issue the receipt in full proof of discharge of the liability. In case of temporary disablement means which is recoverable, it is not permanent. If the person has suffered any, say suppose fracture in both the legs, so he is on the bed with plasters. After 4 months the plaster is cut and his legs are okay. So he has suffered only temporary disablement because this is recoverable. In such a case, the method of compensation payment is different. That is the amount of compensation is a half monthly payment equal to 25% of the monthly wages. So for this also the formula is there. Now, this is a calculator which is already provided with the branches. Premium can be calculated. But there are certain exclusions in the policy. And the most important one is any injury which doesn't result in fatality means death or partial disablement for a period exceeding 3 days, means first 3 days will be deducted, for rest of 3 days the amount will be paid. But under these three circumstances, when the worker was under the influence of drink, when the worker has done willful disobedience of an order, when the worker has willfully removed or disregard to the safety guards. Because the fact is, the employers are providing safety guards like headlight with torch, the cap with the torch, boots, gloves, jackets. Safety guards are to be there. Willful disobedience means he was assigned some accounting work and he started working on the machinery. So this is, the employer will not certify. This was not his assignment. Or if he was under the influence of drinks or drugs, accident is bound to happen. So under these circumstances, the insurance company will not pay any compensation under the policy, because these three, drink and drugs, disobedience and disregard, are the exclusions of the policy. And one big exclusion of the WC policy is if the worker dies his natural death, no compensation is paid. There is no accident. This liability is not covered. Natural death liability is not covered under any of the general insurance policies. So with this, the picture is clear now. But an important question can be asked to you. Sir, if the worker has been paid the amount under a group personal accident policy, still he or his dependent has got any right to claim under the WC policy? The answer is yes. Because group personal accident policy is altogether a different policy which is always optional. The employer is taking or not, it makes no difference. But WC is statutory liability. If WC policy is not taking, then he has to pay the compensation from his own pocket. A lot of differences are there. The premium calculation of group personal accident is different. Claim compensation is different. Coverage of the policy is different because it is 24/7, that is round the world. And WC it is only for the working hours. So both policies are different. And the worker has got a right to get the compensation under WC, and if there is any good GPA, that amount also. So there is a decline list which doesn't allow you to issue policy to the workers working at a height, working in an area surrounded with the water, working in a metal forges and foundries, blasting in tunnelings, chemical industries. Or you should also not give this policy where the ESI is applicable, because ESI is already providing the coverage for the workers. Now, if there is any incident of the death or disability, you only have to guide the insured to submit certain documents like claim form with the detailed incident, medical certificate, wage statement, proof of age. But here in the claims, one thing is guaranteed, that it should be due to accidental reason. And for that accidental reason, FIR will be there, Panchnama will be there, MLC will be there, photo ID and age proof, salary proof, even the disability certificate of the doctor would be there if there is any kind of disability. Or if there is death, then in that case postmortem report is required. Because in every accidental death, postmortem is must. Now the important thing is to whom you can sell this policy. To the contractors, to the labor contractors, shops, factories, labor associations, factory inspectors. Even to the house owners you can give this policy, because if you remember in our home care policy, there is a section called WC. House owner may have gardener, driver, cook, servant. So this liability is also insurable under the WC policy. If the worker who has suffered any injury and he is claiming from the WC code, then only the provisions of this act will be applicable. If he is filing the case in any other court for compensation, this limit will not apply. Then the amount of award will depend upon that court. Because for this purpose there is a specific court where he can file the case. In otherwise courts, it depends upon the courts how they are providing the compensation. So this is all about the WC insurance. If you have any questions, you can ask.
सर इसके अंदर कुछ है ना, इसमें कोई भी ऐसा स्पेसिफाई नंबर है WC पॉलिसी ये नंबर को दे सकते हैं या सिंगल पर्सन?
You mean limit of workers?
Yes.
That depends upon the proposer. What project is there? Because in a project, suppose
Just you say कि है ना होम सर्वेंट को भी दे सकते हैं, ये घर में एक
no limit. That each proposal is valued on its own merits.